There is some legal news today. A judge is expected to set a trial date in the federal election interference case against former President Donald Trump. At 10 o'clock Eastern time this morning, lawyers for both Trump and the Justice Department are scheduled to appear before District Court Judge Tanya Chutkan for a status hearing. The team for special counsel Jack Smith has proposed the trial begin in early January of this coming year. In response, Trump's lawyers requested the trial not begin until April of 2026. The former president has pleaded not guilty to 4 charges related to his alleged efforts to stay in power following his 2020 election loss to Joe Biden. Meanwhile, regarding the charges against Trump and 18 co-defendants in Georgia for election interference, former White House Chief of Staff Mark Meadows is pushing to move his case from Fulton County to a federal court. There are at least 4 witnesses subpoenaed to testify at today's hearing on that matter, including Georgia's Secretary of State Brad Raffensperger. Meadows was on the now infamous call where Donald Trump asked to find the necessary votes to win the state.
I only need 11,000 votes. Fellas, I need 11,000 votes. Give me a break. So, look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have, because we won the state. There's nothing wrong with saying that, that you've recalculated.
January 2nd, 2021. Meadows plans to argue he was acting in his capacity as the top aide to former President Trump, so it should be in federal court. Also today, the court will be considering a push by several of the defendants for a speedy trial. Let's bring in NBC News Justice and Intelligence correspondent Ken Delaney. And Ken, good morning. Let's go back to the federal matter first in Washington with Judge Chutkan announcing, we think, at about 10 o'clock this morning after that hearing, a trial date for the Jack Smith special counsel prosecution of Donald Trump for an attempt to overturn the 2020 election. What are you hearing about that gulf between the proposed dates? One early January 2024, the other from the Trump team, April of 2026. Where might it fall in there?
Good morning, Willie. Well, both proposals are probably unrealistic, but the Trump's team proposal is sort of in left field, is not even remotely realistic. So most legal observers believe that Judge Tanya Chutkan is going to set a trial date sometime next year before the November 2024 election. It's not likely to be in January of next year. It could be around this time or in the summer at some point. And whatever date she sets may not hold, but it'll give us an idea of her thinking about how quickly this case can get to trial. I'll be covering this hearing outside of that federal courthouse today. It's actually, as pretrial positioning goes, this is probably one of the most important pretrial hearings in this case because of the profound effects on the election. And it's really our first chance to hear from Judge Chutkan on a really important matter.
So Ken, can you just spell out then what this could mean in terms of the timing and the run up to the election, and what we might learn by the end of today?
Well, okay, we're going to learn, exactly how Judge Chutkan views this case in terms of its complexity and whether she buys at all the defense arguments that, because they're receiving 11.5 million documents. Remember, they said equivalent to reading War and Peace 8 times a day from now until the beginning of the trial. Whether that means that they need a year or more to prepare for this trial. The prosecution, the special counsel, has said that's ridiculous. Yes, it's a lot of documents, but we're in a computer age. You can use keyword searches. We're going to help you tell you what the key documents are. Besides which, a lot of this evidence is very familiar. It was developed and made public by the January 6th committee. So we're going to see what Judge Chutkan thinks of these arguments and whether she sets a trial date before the summer, before the November election. It's really going to set the tone for where this thing goes from here.
So going down to Fulton County, Georgia, Ken, Mark Meadows has said, I want this in federal court. I don't want to be tried by Fani Lewis. I don't want to be prosecuted by Fani Willis. So what is your sense of his chances of that? Most people say that's probably a long shot. Do you think there's a shot he gets it moved out of there?
I think there's a better chance than, say, Donald Trump had when he tried to do the same thing in the New York case. But just to be clear, I've been told actually that The Georgia prosecutors, the DA, could continue to prosecute this case in federal court. They may have to bring in prosecutors who have federal experience. They may have to file some paperwork to appear in federal court. But nothing would change about this case if he wins, except that it would be heard by a federal judge. It would still be the state charges. It's a weird 1789 law designed to protect federal officials who are acting under the color of their authority in office. Of course, the biggest argument against Meadows in this situation is, you heard the tape there, the recording. Donald Trump was not acting as president in that moment. He was talking about the election. He was asking the Secretary of State of Georgia to find votes. So if Meadows was sitting in that meeting or involved in that meeting or other activities like that, and he claims he was acting as a federal official, the DA is going to say, well, sir, then weren't you violating the Hatch Act, which prohibits federal government officials from engaging in politics? So it'll be interesting to see exactly what his argument is there, Willie.